Hi, I'm Rob Carolina. This is one part of a multi-part introduction to the Law and Regulation Knowledge Area of CyBOK. The Law and Regulation Knowledge Area is one of 19 knowledge areas in the entire project. The webinar that introduces this knowledge area is pretty long, and so I decided to break it up into 15 constituent parts. You are now about to listen to one of those parts. If you haven't already done so, I would recommend that you go back and listen to the introduction. It's also labeled Part 0. That'll help you understand what's about to happen. Alternatively, you can listen to the entire webinar as a single file. So without further ado, let's listen to this part. Now I'd like to take a quick look at public international law. Let's start with the basics. Public international law exists to regulate relationships among and between sovereign states. And for this purpose, we include international governmental organizations, treaty organizations, like the United Nations. Where do you find public international law? It's found in treaties, custom, widely accepted norms, decisions of international tribunals. The trick with public international law is how do you enforce it? Yes, there are international courts, but those courts have very limited power to impose their will onto sovereign states. And the truth of the matter is that states most often have to resort to a type of self-help. They enforce international law against each other. Very often that's taken by means of what we call countermeasures. How does international law apply to cyber operations? Well, let's be upfront about one thing. There is, to my knowledge, no existing international treaty on how states are supposed to treat each other in cyberspace. What we do have is a very long and well-understood body of international law that regulates how states treat each other anyway. Most states today seem to agree that existing international law applies to cyber operations, but they don't necessarily agree how to interpret that law in the context of cyber operations. That leads us immediately to the Tallinn Manual, specifically the Tallinn Manual 2.0. This is the world's leading source of expert analysis on how international law applies to cyber operations. Some of you will already be familiar with the Tallinn Manual. It was written by a group of expert international lawyers. The project was funded by NATO, but it does not constitute official NATO doctrine. And for that matter, I don't know of any single state that adopts the Tallinn Manual as a definitive statement of international law. It is, however, a regular foundational source that people use to try to inform their understanding of how international law applies to cyber operations. That's why it is very extensively cited in CyBOK. Someday we may find a number of decisions by international tribunals or the UN Security Council that will help inform our understanding of how international law applies to cyber operations. Until then, this is the best single source that we have. Now, don't get me wrong. There are many good sources of argumentation and academic scholarship in the field of international law, and I've cited a number of them in CyBOK. There are many, many more available. Each of them represents the opinion of perhaps one or two people. The strength of Tallinn is that it represents the opinion of a wide group of experts who came down to try to hammer out what they thought was the lowest common denominator understanding. A common problem in dealing with international law, especially in cyber operations, is the problem of state attribution. In other words, how can we prove that a given act is the responsibility of a given state? Attribution really can be thought of in two different forms. There is the legal standard used to assess whether or not an action should be attributed to a state. And then there's the process of forensic investigation to try to gather evidence used to satisfy that legal standard. In CyBOK, I'm only speaking about the legal standard. And one of the strengths of Tallinn 2.0 is that they greatly expanded their coverage of how to understand attribution of state action. The three basic theories of attributing action to a state is, number one, if an act is actually undertaken by an agent of the state. So if a particular cyber operation was undertaken by a person wearing a military uniform, sitting at their desk in a military base, then it's pretty clear that that action is attributable to the state where they are an officer or agent. The second gets a little bit more confusing, and that is a circumstance where a sovereign state might encourage or indeed direct a non-state agent to undertake a cyber operation. Here we're talking about states who either contract with service providers who undertake operations for them, or alternatively, where states perhaps informally encourage groups with whom they don't have a contract necessarily, but nonetheless kind of encourage them along. Sort of like hints and suggestions. It would be a good idea if you and your friends would attack something or undertake a certain type of operation. That type of encouragement suggests that a state should be responsible for the actions that they've encouraged. And finally, one of the more controversial theories in Tallinn is this idea that a failure to exercise due diligence over cyber infrastructure can lead to responsibility for the state that doesn't look after its own backyard. And this is the theory that if you as a state are unable to police your cyber infrastructure, or if you turn a blind eye to all the awful activity that's emanating from your cyber infrastructure over there in your state, if you do it long enough and seriously enough, then we, the rest of the world, it should be fair for us to attribute the bad actions coming out of your state to you because you have failed to put an end to it. Not everybody agrees with that principle, and you can read more about the argument around this both in Tallinn 2.0, and there's a fascinating article that I've cited on that point as well. In each of these three legal standards, think for a moment, what kind of evidence would I need to get? What would I have to gather and present in order to prove that that standard had been met? How can I tell if somebody wearing a uniform of that state was actually directing the operation? How can I prove to policymakers, to the international community, that a given state had encouraged a disconnected organization? So that is the problem of forensic investigation, and unfortunately, where confusion arises is when people use the word attribution, they think only about the evidence gathering, and they don't necessarily think about the legal standard that they're trying to meet. Basically, when you look at international law, it's designed to limit how states deal with each other. It's designed to limit and rein and hold back exercises of state power. So, basic prohibitions. A state is not supposed to violate the sovereignty of another state. A state is not supposed to use force against another state or make an armed attack against another state. You can see that each of these is increasingly more severe. Well, what constitutes a violation of sovereignty in the age of cyberspace? Different people come to different conclusions about that, and there's a lot of discussion of this in Tallinn 2.0. Use of force. Now, this is an area where there seems to be a bit of convergence about what we're talking about. Basically, if you see a kinetic effect out in the real world, if a cyber operation directly causes something in the physical world to be damaged or a person in the physical world to be harmed, then it probably amounts to what international lawyers call a use of force. Finally, an armed attack, something much worse. So what happens when a state does one of these things, uses force, or makes an armed attack without justification? That leads us to the subject of countermeasures. Countermeasures are a knowing violation of international legal principles in an effort to remedy or, let's say, get back at a state that has itself violated international legal principles. And this becomes a very dangerous game. One of the key ideas behind the law of countermeasures is that countermeasures must be proportional. So if a state does something kind of a little bit bad to my state, then my countermeasure has to be down at that limit of only kind of a little bit bad in response. And countermeasures, of course, to a cyber operation don't have to be a cyber countermeasure. That leads to a problem that nobody seems to have an answer to right now, which is how do you compare the severity of a cyber attack with the severity of a non-cyber countermeasure? At what point does a cyber attack justify an economic sanction? At what point does a cyber attack justify a kinetic response? Finally, if states are actually in armed conflict with each other, then a slightly different set of international legal principles starts to come into play. And the four principles that are always cited in this area are that armed conflict, when you're making a decision about what to do in the middle of an armed conflict, how far can you go? How much force can you use? How hard can you hit? The principles are you should only do things to the degree that they are necessary for legitimate military objectives. You have to respect what's called the principle of humanity, which is you should not cause more human suffering than is strictly necessary. The principle of distinction. You should target military objectives and not non-military objectives. And proportionality. Once again, the amount of force that you use has to be proportional to the circumstances. Now, how do you apply any of these principles or all of these principles in a cyber environment is something that we'll probably have to learn in the decades to come. In particular, you might want to have a bit of reading on the subject of distinction, because so many of the state's functions have now been transferred into cloud service operations. There is a lot that's been written about how do we tease apart the difference between a military and a non-military objective when you have certain types of state functions or military functions that might be co-located in a cloud instantiation of some type. And now we turn to a